the judge in that case doesn't believe that that was a sentence, that what could happen is your plea in this case would then be considered a violation, and that court could sentence you to the maximum allowable under that other charge. Court calls the case, People versus Lawrence Turner.
Peyton DeWitt on behalf of Mr. Turner should be appearing by Zoom.
Nope, I'm kidding. He's here. Mr. Turner, can you state your name, please?
Lawrence Turner.
Thank you, sir. All right, what are we doing?
We should have a plea deal today.
Oh, there is a plea form. Plea form indicates that the defendant would be pleading guilty to an added count to a false pretense is 200 to 1,000 to 1 year offense. Upon a successful plea, count one would be dismissed. That is the court's full understanding of the.
That is
correct. Sir, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Correct.
State your name again, please.
Lawrence Turner.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of false pretenses 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property, which is the subject matter of the false pretenses. If that's greater than $2,000, that becomes the maximum fine. You understand that, sir?
Yes.
All right. So you also understand that by pleading guilty, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court. You understand that, sir?
Yes, understood.
All right. And understanding all of that, do you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind.
Correct.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that, sir?
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Yes.
Which one? Probation?
Probation, yes.
All right. Were you on probation at the time of this offense?
Correct.
I'm sorry, I didn't hear you.
Correct.
You were? Okay. I do have to advise you that your entry of a plea in this case could be considered a violation of your probation. You understand that?
They already incarcerated me for the violation.
Okay, I'm not sure what they've done. I do have to advise you that it could be considered a violation. You understand that?
Yeah, no, I already dealt with the violation when you guys had reprimanded me. That's when I had
say again.
When I had got let out with the personal bond, I had dealt with my probation officer, and they had incarcerated me for the violation. So I already dealt with the violation.
Yeah, I think he's trying to inform the court that he's his probation is aware. He informed me that he was already sentenced on the violation, but he fully understands that this could be a violation of his probation.
Okay. And the other part of that is, if what you're indicating to me was not considered to be a sentence on your violation, that other court could sentence you to the maximum allowable under that other charge. You understand that, sir?
No. So you're saying basically I could be violated again for this particular charge?
Well, hang on. What I'm indicating to you is I don't know whether or not they violated.
No,
I
they
have
did.
to apprise. Let's just hang on. I just have to apprise you that if this is considered a violation and they haven't done anything else, or the judge in that case doesn't believe that that was a sentence, that what could happen is your plea in this case would then be considered a violation, and that court could sentence you to the maximum allowable under that other charge.
Gotcha.
You follow me?
Yeah.
So and just so that you understand, I don't know what happened with any of the other stuff. I just have to apprise you that that's a possibility.
Gotcha.
Okay. So now my question to you is, are you 100% sure that you were sentenced on this violation? Or you're not sure? It's okay if you're not sure.
No, I'm about 95% sure because when I got let out, I had to go see my probation officer, and then I had to go see the judge on behalf of this matter. So by me addressing this exact matter with Washington County in Warren District, that was me thinking that, hey, they're violating
Well,
my
no,
probation.
I got you. But who was your judge?
This was what's his name? I can't think of it off the top of my Judge Schupa, out of 37th District Court, Warren.
Okay. So it wasn't here in Washington. It was someplace else.
Yeah, because my probation was in 37th District Court in Warren. So yeah, when I got out of jail
Warren.
to probation, they found out
Okay.
that I arrested on
All
behalf-
right. All right. I got you. Just hold on a moment. Are we sure they've done something? I mean, I'm hearing him and he's sure. I'm a little bit worried. I get what he's telling me. He's about 95% sure. But if that 5% happens, I think he might be a little bit upset.
Man.
I did not speak to his probation agent or confirm his work. But he said for me that he's been reporting and that they were aware of it. And he informed me that he's actually scheduled to be discharged
This
in the
month.
very near future.
All right.
They are
Hey,
aware of this case pending, but I did not confirm that he has been sentenced
on.
on this violation.
All right. So, all right, young man, here's what I'm going to do, because part of what I have to do in taking this plea is make sure all of your rights are protected. That's why I have to ask the questions. Okay. And what I would prefer to do, because I don't like that 5%. If he were 100%, I might think a little bit different, but he's about 95 and I don't know that he's at really 95. I would rather adjourn this out. Have you checked that? Have your counsel check that? Everybody make sure so that what you're doing, you don't end up caught up again.
Right.
Okay. So that's what I'm going to do. It's not your counsel's fault or anybody else's fault. It's just me stopping this just to make sure, because I don't have that information that you're talking about in front of me. Okay.
Gotcha.
Mr. Turner, if you could contact your probation agent and give them my information to give me a call, that'd probably be the best way.
I got you.
Okay. Yeah. Okay. So here's what I'll do. Probable cause conference will be adjourned. Then why don't I just make it July 2nd, 2024, 9 a.m. or as your invite indicates. All right.
Gotcha.
Can he appear via Zoom?
Yes, can he appear?
No, I think we've got to drag him down here. What do you think, Alan? No, he can appear via Zoom.
Thank
All
you.
right. Okay. All right. We'll see you then, sir. Is he executed in? May I have him sworn?
Right. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the help you got?
I do.
State your name.
Russell Dion, Swapshire.
Sir, it is this court's understanding that you're going to plead no contest to the charge of embezzlement by an agent or trustee, 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
I do, sir.
Do you understand what a no contest plea is?
Yes, I do.
All right. 2 things about a no contest plea I need to make sure you understand.
Yep, well, they definitely explained it to me.
Who did?
Both my lawyers.
Miss Apple
The intern.
and she explained it, Mr. Witt?
Well,
You probably understood Mr. Witt a lot better, didn't you? Right?
We did.
Yeah, see? See, I'm just trying to get all this straight. Okay. 2 things about a no contest plea I have to make sure that you understand. And first of all, it means that you're not further desirous or wanting to contest this charge. You understand that?
I do.
The second thing you need to understand is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that? All right. Now, you also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yep.
You understand that? All right. Counsel, the basis for the no contest plea?
Potential civil liability, Your Honor.
Got it. I did. Sir, to that charge, how do you plead?
I believe no contact.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
That's what I wanted.
Oh, okay. You signed an advice of rights form today?
I did.
Any question regarding any of those rights?
No, I do.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading no contest, you'll be giving up those rights as well as all the rights amendments.
Mm-hmm.
That a yes?
Yes,
All right.
I
You understand you're giving up your right to appeal upright.
I agree.
Are you on probation or parole?
No, I am not.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead no contest? Has anybody threatened you or coerced you?
No.
You're doing this voluntarily and of your own free will.
Or yes.
Counsel? No, this is Miss Apple's fault. I don't have a police report. Do you have it?
Your Honor, I see what happened to the court. I apologize.
Now, did you send it?
I did.
I think if Mr. Witt had done it, it wouldn't have gotten lost. Just my thought. We have it, but your fault.
Collectively, it's our.
Nothing is Ann's fault. I just need you to know that. Should have just taken it, Emily. I tried to blame it on Apple, but she said it. Wow.
Very good.
Yeah, what'd you do? Yeah, what'd you do? I don't think we have that much faith. Hold on, we'll get it. It'll get here eventually.
It's still going?
Yeah, it's still going. You know what you did. Okay, fine. Seriously?
I think it's just reporting over and over. It's gotta be.
Oh, you think it's just repeating itself? Yeah, okay.
I was gonna say.
Just add to your court.
Can't say it's a sheet.
I don't have a big staple.
That is thick. That is.
You don't have a big enough staple. It's like we killed like 8 trees. Everybody do what you're gonna do. This will take me a minute. Did they give, I see all of the receipts. I think I've got enough on the receipts for the council. I've been handed and our printer was broken by Washington County Sheriff's Office report. Their case number 23-30672. Any objection to the court having reviewed that report?
Thank you.
No objection.
All right. Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court?
Everyone's dissatisfied.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. A pre-sentence investigation and report is ordered at 14B. Probation sentencing in this matter will be
July 25th at 10 a.m. before Judge Washington.
July 25th, 2024, 10 a.m. before Judge Washington. Bond in this matter will continue. Court calls the case of the People versus Matthew Moore.
For the people. Ready to show please for Assistant Public Defender appearing on behalf of Mr. Matthew Moore, who is approaching. Who's approaching, Mr. Moore, please state your name for the record.
Matthew Moore?
Oh, sorry.
Thank you, Judge. I have spoken to Mr. Moy and to Mr. Ganatra. My understanding from Mr. Ganatra is that Mr. Moy is 7411 eligible. Based on that, we are requesting to waive this matter to circuit court. He's on probation there already. His agent knows all about this already, and we're hoping to get a concurrent probation there under 7411, Judge.
You're intending on waiving your preliminary examination?
Yes, sir.
All right, you understand that a preliminary examination is a proceeding where the people have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, Your Honor.
And you understand you will not have that hearing and you'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
We do.
Preliminary examination having been waived, defendant is bound over to circuit court on a single count.
Thank you, Judge. We would waive reading stand mute, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
July 24th at 1:30 before Judge Conlon.
July 24th, 2024, 1:30, Judge Conlon.
Thank you very much, Judge.
Thank you.
Bond will continue. Court calls the case, People versus Matthew Fleury. Whoa. Matthew Fleury? Oh, I'm sorry, he is. Got it?
Prosecuting attorney, Gordon Lewis, on behalf of people.
Water system defender on behalf of Mr. Fleury.
Your name, sir. Your name?
Sorry, Judge.
Matthew Fleury.
Thank you. What are we doing?
Your Honor, date and time set for probable cause conference on case 24 FB 1157, which I believe is the CCW case. Mr. Fleury will be waiving his right to a preliminary examination, and we would ask that the other matter be set for.
On the matter that you're requesting to be set for preliminary examination, is all discovery complete on that case?
That is correct. I do want to note that I did make a request for a 911 call and I was notified by dispatch that this was initiated as a traffic stop, so there is no 911 call. All other discoveries.
All right.
That is my understanding as well, Judge.
And would the people have their witnesses available the 25th? Preliminary examination, this is in case 1158. Preliminary examination in person, June 25th, 2024, 9 a.m. That is before Judge Washington. Bond will continue in that manner. Sir, on your other case, my court's understanding is that you're waiving your right to preliminary examination. You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them. You understand you'll not have that hearing on that case and you'll proceed to circuit court for further resolution. Yes. People also waive their right on that matter.
Yes,
Preliminary examination having been waived, defendant is bound over to circuit court on all 3 counts.
Your Honor, I will acknowledge receipt of the information, waive its formal reading. My client stands mute.
Defendant never waived formal reading, standing mute. Court will enter a not guilty plea to all counts. Pretrial will be set for
June 24th at 1:30 before Judge Slade Monday.
June 24th, 2024, 1:30, Slade Monday. Bond continued. Court calls case People versus Taylor Dixon.
Both use on behalf of the people.
Your Honor, Peyton DeWitt, student attorney requesting permission to practice pursuant to Michigan.
Hold on. Didn't hear your last name either? Okay, I'll get it.
Peyton DeWitt, student attorney requesting permission.
Okay, sir, slow down a quick second. You need to clearly state your name and spell your last name because we don't have it.
Okay,
Because who's your supervisor?
Hannah Apple.
She didn't give it to us. So no, don't go. That's her. That's on her. You go ahead.
Peyton DeWitt, it's DEWITT.
Told you. Go ahead.
Requesting permission to practice.
Are you going to read that? Or do you know it?
I do know it. but
Do
I-
you? Okay, then look me in the eyes and tell me what you want to tell me.
Requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Public Defender Hannah Apple.
Very good. Okay, where are you from?
From Canton.
Canton? Faraway land of Canton. Where'd you go to school?
I go to University of Michigan Law School.
University of Michigan? Sorry. Don't know. I'm a terrapin. I don't like anything. But that guy's a Spartan. And so you're better than me. Yeah. All right. Yeah, I said it. Permission to practice is great.
Thank you. Ms. Dixon, will you state your name for the record?
Taylor Dixon.
Thank you, ma'am.
Thank you.
All right, what are we doing?
Your Honor, we've been trying to contact Ms. Dixon and we've been unable to do so far. So we're just asking for an adjournment so we can discuss things over with our client.
You set her up here to do that, didn't you?
Sure did.
So what if I deny it? Would she know what to do if I deny it?
Probably not, to be honest.
You're like, I don't know. All right. Ms. Dixon, I'm going to adjourn your probable cause. Get in contact with your attorneys July 2nd, 2024, 9 a.m. Okay?
Okay, sir. Yes,
All
sir.
right. Thank you. Your bond will continue. Thank you.
Okay.
You're welcome. Yeah. Court calls the case People versus David Doble.
Maria Sinski on behalf of Mr. Doble. Please state your name for the record.
David Doble.
Thank you, sir.
Your Honor, we would be asking for an adjournment for continuing negotiations with the people. And if I may briefly address a bond condition.
Oh, you want me to you want me to lock him up?
No, you're not.
Hold on. Probable cause conference. I'll make it July 2nd, 2024, 9 a.m. Okay. And yes, let's do a bond condition.
Your Honor, it's my understanding that there was a stipulation for the modification of bond conditions signed with Mr. Childers and Ms. Anderson previously, which allows my client to go to the complaining witness's house until June 14th to care for his fish. And I have a copy of this if you would like it.
Your Honor, to be clear, the victim is residing at the home, but she is on vacation until the 15th of this month. There are some very expensive and high maintenance fish that are in very large tanks, and there's a large number of them. The victim has been trying to get a third party to care for the fish while she's gone, but has been unable to do so because caring for them requires some specific maintenance, which Mr. Doble is familiar with. She did consent to having Mr. Doble go to the residence, but not stay overnight there to care for the fish until she returns.
And is that what the order indicates?
Yes, that's correct.
We were not sure if it had been submitted to the court yet.
I have not. I don't seen it, have I? No. Seriously? Mr. Zinke, when you were on the other side of the table, how long were you in my court? It was like decades.
8 months.
Well, okay. Close. When I get it, this is Anderson's fault. Where is Kalina Anderson? Everybody's like, Mom, we don't even know her. I never sign anything that's two-sided. Isn't that right, Ms. Gaines?
That is right. I did not realize it was two-sided.
Oh, you don't have to fall on the sword. Kaczynski knew it. She was just gonna, yes, you did.
I did, but I didn't realize that, yeah, you did sign things.
But I will.
I'll sign it. Bond will continue. I'll add that as a condition, sir, okay? Sir, you understand that?
Yes, Your
Mr.
Honor.
Doble? All right, so you'll be able to do that. I'll sign the order as soon as I get it in its proper form.
Thank you, Your Honor.
Thank you. For cause case People versus Wayne Eggleston or Eggleston.
That Wayne Eggleston, Your Honor.
Pardon?
That Wayne Eggleston.
Yes.
I'm gonna pull you on behalf of the people.
Assistant Public Defender Davi Lieb on behalf of Mr. Eggleston, who is not present. I have discussed Mr. Eggleston's lack of presence with Ms. Hughes. He's currently in treatment and I have provided proof to that effect to Ms. Hughes.
All right, so what do you want me to do?
We're requesting an adjournment, Your Honor.
Any response from the people?
I let the council know that I would leave it in your honor's discretion, and I noted that we got another community corrections violation because we still don't have the work it testing results, and defense counsel said he would work on getting the release for community corrections.
I think you said that to me last time.
Not me. I did attempt to.
He was gonna throw the rest of his office under the bus. It wasn't me.
I did attempt to contact Mr. Eggleston regarding that. Unfortunately, while he's in treatment, Sacred Heart, the only way to contact him is via his therapist there. I did leave for an additional message after Ms. Hughes alerted me to the testing issue. Unfortunately, I did not receive a return call.
July 11th.
Thank you, Your Honor.
Bond continue. Or cause case People versus Deshaun McFarland.
Good morning, Your Honor. Sam Bernstein with on behalf of Mr. McFarland. Sir, what's your name for the court?
McFarland.
In this case, Your Honor, we're asking the court to please set for exam. Discovery should be complete.
That is correct, your honor. Discovery.
People would have their witnesses available the 25th. Preliminary examination, June 25th, 2024, 9 a.m. before Judge Washington.
Your honor, there is one matter.
Of course you would. Go ahead.
Your honor, I do want to note that there have been no calls directly to the victim. However, I do have notes that, and I did notify Mr. Burns that I have this, as well as request to have the jail clothes released to him, that the defendant has been talking to his grandmother and informing and instructing her to contact the victim about dropping the CPO. I am extremely concerned. This is not an isolated phone call, but it seems to be repetitive and continuous and come up in multiple conversations. As a result, I also want to follow up and say that it does appear that the victim was contacted by the grandmother, according to later conversations, and that she said she would not be dropping the CPO. She wants to keep it in place for a year and see how he does. But at this point, it's not just a request for indirect contact, it is successful indirect contact. I would be requesting for his phone.
Well, it certainly hurts the bond argument that I was planning on making today, Your Honor.
Well, I'll just say this. I'm a bit concerned that the contact was made and that the contact that's made is of a nature that is obstructive. It wasn't just, hi, how you doing? That concerns me. So two things are going to happen here. Defendant's phone privileges are hereby ordered revoked. Defendant's bond is also increased to $200,000 cash surety.
Waiver Since on behalf of Ms. Knoll, who is approaching to my right, please state your name for the record. Michelle Knoll.
All right, what are we doing?
Your Honor, we would be asking for an adjournment. We have just sent in the referral for sobriety court. And if I may address bond
You
when the
need
time
me
is
to sign
appropriate.
off on this. All right, I did that. I signed off on the referral. So yes, go ahead. You can address mine.
Your Honor, Ms. Knoll, her mother is in hospice and she's a caregiver for her. And she would like to be released and she would be happy to comply with any testing that the court would offer. She's had time to reflect and gained a positive outlook from this experience. And she's been incarcerated for over 45 days and she was the one that turned herself in for this instance. So we would be asking the court release her on any conditions that the court feels is appropriate.
Any response from the people?
And I think that it's convenient to make corrections to the updated report dated June 6th. I don't know if you have a copy.
I do.
And it gives a fairly thorough reference of what she did or did not do on release conditions.
Put her on the scram tether, or she was on a scram tether. And we weren't able to stop, or she wasn't able to stop herself. So I'll be honest with you, counsel, frankly, I don't know the amount of options. That's gonna be the problem, so. Did I adjourn this out already? How much time did you need on this? With the referral?
A month, Your Honor.
Probable cause, July 11th, 2024. 9 a.m.
Your Honor, if we could actually get 2 weeks.
2 weeks.
Yes, thank you.
June 27th, 2024, 9 a.m. And maybe be able to see her sooner. Your motion for bond reduction or change in bond is denied at this time. I don't have a way to keep her safe, the public safe, or anybody else safe, given the violations that I see regarding the scram. So that's denied. Bond will continue.
Thank you, Your Honor.
Hey, folks, we'll just have to slow roll it. Everything else is in custody. Court does call the case, People versus Bruce Pickens.
Render being written on behalf of Mr. Pickens. Mr. Pickens, state your name for the record, please.
Bruce Pickens.
Your Honor, today is the date and time set for probable cause conference. We are respectfully requesting this matter be set for preliminary examination at the earliest date.
You have all discoveries complete.
To the best of our knowledge.
Your Honor, I did request a 911 call in this case earlier this week that I have not yet received, but all other discoveries.
Would that affect your?
No, my client is incarcerated and they're delaying getting us a 911 tape would only pardon. No, my client is incarcerated. We will be ready.
All right. Put on here no adjournment regarding 911 call. Preliminary examination in person, June 25th, 2024, 9 a.m. before Judge Barr.
Thank you, Honor.
Court calls case, People versus Cottrell Roberson.
Good morning to the most fair judge here. Rushing, appearing on
There's
behalf of
only
Mr. Rowe.
one judge in the room. That wasn't.
I mean, it makes
that was
me-
not a compliment. Go ahead.
Appearing on behalf of Mr. Roberson. Mr. Roberson, will you state your name for the record, please?
Cottrell Roberson, sir.
Thank you. Your Honor, today is a date time set for a probable cause conference. I was appointed just late yesterday afternoon, so at this time, we're going to need an additional PCC date for me to receive discovery.
All right. Did you want 1 or 2 weeks?
1 week preferably, so that way you can wish me birthday. Happy birthday.
Is that your birthday?
The 21st.
Well, I'm not wishing you happy birthday. It's not
It's
her
just
birthday.
early, Judge. Come on.
Okay.
I thought you were fair.
Wow. Probable cause conference, June 20th. Make a note of that, Ann, because I'll forget. 2024, 9 a.m. Bond continue.
Judge, may I address bond or would you like a written motion prepared?
Probably a written motion, which is going to move this, but if you get a written motion.
Okay, got you. Okay, then Judge, at this time, we're not going to address bond. Thank you.
All right, bond continue. Thank you.
Have a great day, Judge.
You do the same. Court calls the case, People versus Michael Russell.
Attorney on behalf of the people.
How come Ballinger won't let his intern speak? What's, all right, I don't know what the deal is with this intern imprisonment. Go ahead.
Hello, Your Honor.
Hello, sir.
How you doing today?
I'm great, thanks.
All right, great.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Russell. Mr. Russell, will you please state your name for the record?
Michael Scott Russell Jr.
Thank you. What are we doing?
Your Honor, we're asking that these matters be set for a preliminary examination.
All right, all discovery is complete on both cases.
To our knowledge, yes.
And would the people have their witnesses available the 25th?
That's fine.
Preliminary examination in person will be set June 25th, 2024, 9 a.m. before Judge Washington.
Okay.
Bond will continue.
Have a wonderful day, Your Honor.
You do the same, sir. Let's call the case People versus Ronald Sims.
Depending on behalf of the people. Public defender on behalf of Mr. Coaches, Your Honor.
Really?
Your Honor, on these.
Say that. You don't let her come up and do anything. Go ahead. No, go ahead, Mel. I'll listen to you.
Thank you. Please say your name for the record.
Ronald Sims. Thank you, sir.
Submitted waiver matters.
All right. Mr. Sims? You're waiving your right to have a preliminary examination? You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution?
Yes, Your Honor.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant bound over to circuit court on the single count in both cases.
Thank you, Your Honor. As to that, we acknowledge receipt of information, waive formal reading, stand mute.
Defendant every way, formal reading, standing mute. The court will enter a not guilty plea. Pretrial in these matters will be set for
June 25th at 1:30 before Judge Clumpy.
June 25th, 2024, 1:30. Bond continued. Court calls the case People versus Aaron Teachout. I can point to the attorneys that are doing it if you want. Apple. And
We're ready in this matter, Your Honor. Long Brown, Deputy Chief Public Defender, being with, and on behalf of Mr. Teachout.
Your name, sir?
Aaron Teachout.
Thank you.
Honor, today's the date for the probable cause conference. We are respectfully requesting this matter be set for preliminary examination.
All right. And discovery is complete.
Yes, Your Honor. To the best of our knowledge, we have all of the material necessary.
And would the people have their witnesses available the 25th?
Your Honor, the reason I'm hesitant is because the OIC was, nope, looks like he's up. I believe so, Your Honor.
All right. June 25th, 2024, 9 a.m. That is before Judge Barr. Bond continues. Court calls case People versus Theophilus Stellanis.
Not a jazz fan, Your Honor. He's named after
Mr. Williams.
Somebody in his family was a jazz fan.
Yes. Your name, sir?
Thelonious Williams.
That's what I said. All right. What are we doing? All right. What are we doing on this case?
Your Honor, I was just retained in this matter on Tuesday. I do have some of the discovery. I don't know that I have all of it, and I do need an opportunity to go to the jail and meet with my client, so we're asking for a brief adjournment.
All right. I think you're back here on the 27th. June 27th, 2024, 9 a.m. All right. Bond will continue. All right. Thank you, sir. Court calls the case People versus Kerry Wynn. 3 cases.
Kenneth Overwater, Assistant Public Defender on behalf of Mr. Nguyen, who's approaching.
What's he doing?
This will be a waiver, Judge, on all 3 cases.
All right. Mr. Nguyen, is that correct?
Yes, Your Honor.
All right. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them. Yes? All right. And you understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive the right. Preliminary examination having been waived, defendant is bound over to the circuit court on the single count and, well, actually in all 4 counts.
Judge, I've acknowledged receipt of the information in all matters. We'd waive their formal reading. My client stands mute.
Defendant every way formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
June 24th at 1:30 before Judge Slay Monday.
June 24th, 2024, 1:30, Slay Monday. Bond will continue in these matters.
Thank you, Your Honor.
Court does call the case People versus Andre Jones.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Mr. Jones.
Ingham County, they haven't signed in.
Okay, well, then I would ask for an adjournment. I did meet with him.
Hold on. You what?
I did meet with him yesterday
At
at the
Ingham?
Ingham County Jail, and that is where he is.
Okay, then I'll just go 2 weeks out. Is he gonna be there a while or you want me?
Yes, I believe he's serving a sentence and he has about, I think he said he had 4 more months to do.
Okay, let's do this then. I'll adjourn this out to July 11th in that case, 2024 9. And let's see if we can arrange everything for them to get him here with us, okay?
Okay, all right.
Thank you. Bond continue. What calls case People versus Milton Ray?
Nicholas Gazette on behalf of Milton Ray. Mr. Milton, state your name for the record.
Milton Ray. Okay, what are we doing?
We'd like to adjourn this out, see if we can get this case resolved.
Objection, July 2nd, 2024, 9 a.m. Bond continue.
Thank you.
Court calls the case People versus Leonard Jacob.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Jacobs.
Leonard Jacob. Thank you, sir. What are we doing?
We are asking the court to please set this for exam. Discovery should be complete.
People have their witnesses available the 26th, 25th. Emily gave me the 6th. Preliminary examination, June 25th, 2024, 9 a.m. before Judge Washington. Bond will continue. Thank you, sir.
Thank you so much, Your Honor.
Thank you. Court calls the case People versus Sean Jenkins.
Sam Bernstein with and on behalf of Mr. Sir, can you please state your name?
Mr. Jenkins.
Your Honor, we're ready to set this for exam. Discovery should be complete.
On both cases?
Yes, Your Honor.
People have their witnesses available on the 25th. Preliminary examination in this manner. I'm going to give this to you. In person, June 25th, 2024, 9 a.m. before Judge Barr. Bond will continue.
Thank you, Your Honor. Yeah, as well.
People versus Freddie Anderson.
Morning, Your Honor. Mike Gaddy, Assistant Public Defender on behalf of Mr. Anderson, who's here to my right.
Your name, sir?
Your Honor, I'm asking for a brief adjournment in this matter to go over the discovery in some more detail of Mr. Anderson and to also do a little investigation.
Without objection, probable cause conference July 2nd, 2024, 9 a.m. Bond continue.
Thank you, Your Honor.
All right, thank you. Court calls the case People versus Andrew White.
Edward Drugas on behalf of Andrew White.
June 20th, 2024, 9 a.m. Bond continue. Probable cause conference June 27th, 2024, 9 a.m. Bond continue. Court does call the case People versus Michelle Null. Calls case of the People versus Lakita Johnson.
And good afternoon, Assistant Public Defender Don B. Lieb on behalf of Ms. Johnson. Ms. Johnson, could you state your name, please?
Lakita Johnson.
Thank you.
Your Honor, we'll be requesting a 3 to 4 week adjournment in order to conduct some investigation in this matter.
No objection, Your Honor.
Probable cause conference July 11th.
Thank you, Your Honor.
2024, 9 a.m. Bond continue. Calls the case People versus Frankie Enion.
Nimesh Ganatra on behalf.
Mike Gaddy, Assistant Public Defender with and on behalf of Mr. Lenyon, who is standing here to my right.
Your name? Say that last name again. Go ahead.
Your Honor, I've had a chance to discuss this matter with Mr. Childers. We may be able to resolve it. I'd ask the court to adjourn this about 4 weeks to see where we are in restitution at that time.
Got it. Probable cause conference July 11th, 2024. 9 a.m. Bond continue.
Thank you, Your Honor.
Great. Thank you, sir. Court calls the case People versus Tammy Lowe.
Good afternoon, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Ms. Lowe. Tammy Lowe.
Thank you.
But I let Ms. Gaines know that based on the mitigation information that her office provided to us, people are going to file nollie pros. I asked the clerk in our office to prepare one. If it's done today, I'll get it signed and send it to your office. If not, I expect tomorrow morning you'll be able to sign off on that.
All right. So this case is dismissed. Now we'll just do it that way, and then I'll get the order and sign off.
Thank you. All right.
Thank you. Calls the case People versus Anthony. Is it Lucitic?
Kenneth Overwater, Assistant Public Defender on behalf of Lucitic, who is not present. Your Honor, we emailed Mr. Lucitic his court date a couple weeks ago and emailed him again yesterday. I've tried to reach him by phone. I've been unsuccessful. I have no further information about his whereabouts.
Bench warrants will issue for defendant's failure to appear in these matters. Bond in each case will be set amount of $10,000 cash surety. Those warrants will issue immediately. Court does call the case People versus Marcus Moore Jones.
On behalf of People.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Moore Jones, who is here to my right, Judge.
Marcus Moore Jones. Thank you.
Your Honor, I'd ask for, I have had an opportunity to discuss this matter with Ms. Barroso. Your Honor, there is an offer on the table of larceny 200 to 1,000. I'd ask the court for a very brief adjournment to go over this with Mr. Moore Jones, as well as check something an ancillary matter out of.
All right. July 2nd, 2024, 9 a.m. or as your invite indicates, bond will continue. Appreciate it. All right. Thank you. Have a good day. Court does call the case of the People versus Frederick Norman
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Norman, who's approaching now.
goes again.
Mr. Norman, will you please state your name for the record?
Frederick Norman.
Thank you, sir.
Your Honor, we are asking for an adjournment. Mr. Norman is getting some mitigating information to me that I'd like to provide to the prosecution.
Got it. Probable cause conference adjourned to July 11th, 2024, 9 a.m. Bond continued. Court does call the case, People versus Corio.
Assistant Public Defender Davia Lebo on behalf of Mr. Offord, who is not present. Your Honor, I did discuss Mr. Offord's lack of presence with Mr. Ganatra. Mr. Offord is currently appearing in circuit court in a family civil matter that he was not able to have adjourned. Mr. Ganatra indicated to me that he would be willing to waive Mr. Offord's presence today.
For what it's worth.
So he's in another court proceeding on a
Yes.
family matter.
Yes, Your Honor, it is not a criminal matter.
Probable cause conference, I'll adjourn it to July 2nd, 2024, 9 a.m.
Thank you, Your
Bond
Honor.
continue. Thank you. Come on, keep them coming. Is that all? That's it for this block? Just done. And Apple, you should let your intern play. I'm just saying, you do what you want to do. Just saying, but Gaddy knows how I get, and I'll get angry about that if she can't get up there and just,
She's in the next one.
is she?